Welcome, everyone. My name is Tracy Schneider, and I am the Economic Development Collaborative's Communications and Marketing Manager. We are so excited to have you with us today. Before we get started, I'm going to review just a couple of housekeeping items. As this Zoom is held in webinar format, everyone is muted and your cameras are off. This is being recorded, and you'll receive a link to the recording along with today's PowerPoint slides in an email in just a couple of days. Please submit any questions you have at any time using the Q&A button at the bottom of your screen. If you're dialing in by phone today, you can submit your questions via email. Email your questions to webinar@edcollaborative.com. Again, that's webinar@edcollaborative.com. And of course, if you're joining us via computer today, you can use that Q&A button. Our EDC webinars are supported by the wonderful team at Visionality. Visionality helps run the back end of our events, and their fantastic team is available for technical support. If you run into any issues, please put them in the chat. Today, we have Emily and Delaney assisting us. I want to share a quick thank you to everyone who's joined us before and to any of our friends that are new to the EDC and our webinars. Since 1996, the EDC has been focused on providing a pathway to business growth, economic prosperity, and high quality of life for all. Today, our EDC serves Ventura, Santa Barbara, and Los Angeles County-based businesses, community partners, and civic leaders. Hosting our region's Small Business Development Center, the EDC provides no-cost professional consulting with a team of over 50 business advisors. As a community-based lender, our loan program has funded over $20 million in requests and has maintained a commitment of reaching underserved communities with 67% of our loans awarded to women and minority-owned businesses. At the end of today's webinar, we're going to share the phone number for our business assistance line that offers resources and help in English and Spanish. Signing up as a client is always free, takes just a couple of minutes, and provides you with lifetime access to all of our no-cost services. Our excellent staff and advisors are ready to help you build the business that you've always wanted. So today, we're going to be discussing eviction protections and considerations and providing you with actionable items to help you assess your business finances, options, and plans for negotiations. With us, we have 4 Economic Development Collaborative Small Business Development Center advisors and a special guest from the Conflict Resolution Institute. To start us off, I'd love to introduce all of our advisors and have them share just a little bit about themselves and their experience. If you want to go to the next slide, we will start off with our legal advisor, Erica Bristol. Can you share a quick introduction to yourself?
Hi, good morning, everyone. Thank you so much, Tracy. I'm Erica Bristol. I am an attorney and a commercial mediator. I've been practicing since 1999 in commercial transactions and intellectual property. And I'm also a business advisor with the Small Business Development Center at the EDC. Thanks so much for participating today.
Thank you, Erica. Go to the next slide. Perfect. So with us, we have Anthony Elliott, one of our financial advisors, who's going to be discussing business finance considerations. And a quick, fun, wonderful announcement. Anthony Elliott was recently awarded State Star of our Los Angeles Small Business Development Center network for his performance and contribution to the region, as well as his incredible commitment to our business community. We were so thrilled to have you on our team before. You're a fantastic addition, and so it's wonderful to have you share with all of our attendees today.
Thank you, Tracy. Good afternoon. Tony Elliott. I'm an accountant, a CPA. I've been an EDC SBDC business advisor since 2015 and consult with small businesses on items including finance, accounting, tax, business startup, and access to capital. Happy that you joined us today.
Thank you. Perfect. And next we have Bill Bartels, our strategic advisor, who's going to be discussing business options. Can you share a bit about yourself, Bill?
Sure. So I look at events through the lens of strategic planning and organizational development and communications. I've been doing organizational development communications in lots of different domains since 1980 and have been working with the EDC since 2006 and the Small Business Development Center since 2010.
Thank you. Valuable asset to our team, of course. And then last but absolutely never least, Gonzalo Fernandez is also one of our fantastic financial advisors, and he's going to be helping us discuss business negotiations today. It looks like you're on mute, Gonzalo.
Okay,
Perfect.
Mistake number one, be prepared for a few more. It was a pleasure being here. And thank you, Tracy, for the introduction. My background is 50 years in the banking industry. I retired in 2013, and at that time, I joined the EDC SBDC organization as a business advisor, primarily focused on financing, preparation of financial plans, and loan solicitation for those who need assistance in that area. Look forward to our conversation today.
Thank you, Gonzalo. Thank you all for being with us today and sharing your wisdom with everyone here. With that, we are good to go. So I'm going to pass the presentation to Erica Bristol to get us started.
Thank you so much, Tracy. So first, a quick legal update. As many of you know, Governor Newsom signed Executive Order NO 821 back in June to extend the permission given to local governments to provide eviction moratorium in their jurisdictions through September. It's important to realize that Governor Newsom's executive order is not a statewide commercial eviction moratorium. Eviction laws are state statute laws, and what Governor Newsom did was give local governments permission to extend their own protections. It's important to know that while he gave permission to locals, not all of them have actually granted eviction moratorium protections for commercial tenants. Some have not. Those that have granted, the protections vary. So there's no consistent local protection. You really need to look at each one individually and your particular situation. So as you see on the slide, Ventura County, Santa Barbara County, and Los Angeles County have all passed commercial protections. Typically, those protections are for unincorporated areas, and then cities have individually passed their own. Los Angeles County's moratorium says it applies to the entire county, except if a city has passed their own moratorium. So you really have to read the details of each one. Some cities have had moratoriums in place, but then rescinded them, such as Thousand Oaks. And from last year to this year, the moratorium terms have changed or extended from March to present. So again, it's really important, and it was important last year and this year, to check to see if it's been extended or if the terms have changed. It seems like nothing really is changing after this, and everything's going to end on September 30th. However, the individual moratoriums have separate protections. Some of them have eviction protections that are just going to end on September 30th. Some provide additional time for the commercial tenants to repay unpaid rent, and those terms vary from 3 months to 6 months to up to a year, right? Some have restrictions on the commercial landlord charging interest and late fees for that unpaid rent. So you really have to first and foremost figure out where your property is located. If you're a commercial tenant with multiple properties, you need to look at the moratoriums that apply to each location and figure out what the rights and restrictions are. It's important to also remember that the commercial lease is a contract. And so besides the eviction moratorium protections, there are contract law issues, and I'll go into those a little bit more, that landlords and tenants should think about. Now, I put in there versus residential. There's a completely different scheme for residential evictions. We're really not talking about that today. But if you are a commercial landlord of a residential unit, completely different analysis. And please maybe reach out to us or speak to an attorney on that. This is really commercial landlords and tenants. We have heard, even though there are eviction moratoriums in place, that there have been some commercial evictions. It's unclear to me at this point if that's the exception or starting to be the rule. Clearly, after September 30th, we may start hearing more of those. Okay, next slide. So I think it's important for commercial landlords and tenants to remember that the eviction moratoriums, the eviction protections end September 30th. So starting on October 1st, we're back to business as usual, and rent needs to be paid on a timely basis. So for October going forward, if a commercial tenant has not paid rent, there arises new possibilities of eviction. And so we're hoping that's not the case. But keep in mind that these protections for eviction protections won't be going forward in October. Unpaid rent, it just depends on the particular moratorium. If tenants, and this is here really for tenants now we're talking here, if you're negotiating with your landlord, you know, a lot of times it's done orally over the phone, and maybe there's an email back and forth, a discussion of negotiation, but you really should have something that's formulated in a written agreement. Otherwise, you can't clearly prove that you have a negotiated rent or otherwise lease situation. As you're negotiating with the landlord, and we'll talk about that more, and another advisor is going to get into the details of that, make sure that you document. So after you're on the phone, you send an email. After you send an email, if you reach an agreement, it should be in some written agreement, hopefully signed by both, so you have something that's enforceable. And as I said before, the lease is a contract. So it's not just eviction law, it's not just real estate. We have contract law that's in play here. And there's terms in the contract. So besides eviction, these are important terms for tenants to remember. For rent abatement, very often the tenant moves in and gets couple months, 6 months, or a year of free rent. The contract may say that if the tenant breaches the lease, such as not paying the rent, that abatement goes away, and the tenant then is responsible for all that back rent. So look out for that. Landlord and tenant improvements. Sometimes there may be a clause that say if the tenant breaches a lease and the landlord has paid for improvements, the tenant now has to reimburse the landlord for those improvements. There may be a holdover clause that says if the lease ends, the tenant cannot stay at all. They're not going to negotiate. That's separate from the eviction protections for a COVID-19 hardship, right? Sometimes there's a holdover in a 30-day tenancy. So if the tenant stays and the landlord accepts the rent, it turns into a 30-day month-to-month lease. Well, that can be significant for the tenant. If the landlord decides to terminate, they only need to give 30 days notice. Think about all the equipment and materials and inventory you may be having in that space, and now you have to be out in 30 days. Otherwise, there's also sometimes dispute resolution clauses. So if there's a dispute over these things, it may say the parties have to go to arbitration or even possibly mediation. So keep in mind, if there's contract law here, not just unlawful detainer and eviction issues that may create additional rights for the landlord. Some tenants may look at their business and decide that they may need to sell their business. And this is just a reminder, if you have an idle loan, the SBA takes a security interest in all of your business property. And there may be a publicly filed UCC filing statement letting the world know that they have a security interest. We've looked that up for some clients and we've seen that it has been filed. If you want to sell all or even a part of your business property, you may need, and you probably do have to get SBA approval because the property is secured if you have that loan. And finally, for tenants, remember that if you have a personal guarantee separate from all these eviction moratoriums and things that may be on maybe an LLC or a corporation, your personal guarantee may hold you liable and responsible for the rent, separate from eviction. This is a contract law issue. So you really need to look and see, along with your lease, Did you give a personal guarantee? And personal guarantee terms vary, right? We've had one that the personal guarantee ended in 3 years. We had some that the tenant, the individual promised to pay, and now they may be on the hook for a breach of contract, which is just a civil action. So you need to be aware of these other terms and contract issues. Next slide. For landlords, remember that if you have loans, your mortgagor and your loan terms, it may say that you may not alter the tenant rent without approval of your mortgagor. So if you're negotiating reduced rent or other concessions to the tenant, you may need to look at your loan documents and see if you need lender approval for making those changes. Just a reminder. And again, as I said with the tenant, these same terms apply to you. Commercial landlords may have additional rights in that contract, in that lease document. So it's important to look at those terms as well. Again, negotiating with tenants, you need to have a written agreement. It's important to have that in writing. And again, look at the dispute resolution clause to see if there's some things that you must resolve via dispute resolution. And so the bottom line here is that there's a cost and expense to litigation and unlawful detainer, legal fees, filing fees, the time and attention that you have to pay to resolving the dispute and going to court, human resources needed to respond to lawsuits, and stress and anxiety. And so early resolution before September 30th really can be a win-win for both the commercial landlord and the tenant. We've seen lots of different negotiations, such as subleases, allowing the tenant to exit early, reducing rent based on revenue or client return, sale of the business. There's lots of alternatives here. So figuring this out before September 30th can really be crucial to reducing the legal risks and liability that could result from this, from these commercial lease transaction. And that's it for my point. On to Tony next.
Thank you very much, Erica, and some very good legal points as business owners approach the subject of landlord lease discussions. Okay, so before, and I recommend that before a business owner approaches their landlord, they need to take a look at their finances to assess the financial condition of the business. That at a minimum should include possibly looking at your cash flow, your bank balance, your outstanding payables, things of that nature. And during this process, as far as for those business owners who are maybe financially challenged in a significant way from COVID, this may be a time to think about other alternatives in terms of whether or not you're going to possibly close the business. So that would be important. And Gonzalo, to you.
Yeah, thank you, Tony. Following what Tony just mentioned, and assuming that at this point there have been no negotiations with the landlord, that's going to be a challenge, because the best time to negotiate is when you don't have a time pressure. Now you're getting to a time pressure for a negotiation. So quickly you need to identify what the financial options are available to commence the negotiations. If the landlord, for example, says the bank is not allowing me to do any negotiations, that has to take certain approach. If you do not have the cash or the resources available to begin the negotiations, you got to know that. As Tony indicated, you got to know your numbers, you got to know your financials, and be prepared to how are you going to commence these negotiations. And again, keep in mind the limited time available at this point to do that. Tony, back to you.
Some of the key items as part of your financial picture include your cash flow, your sales performance, liquidity, debt capacity, conditions with debt holders, including vendors, taxes, and payroll obligations.
Okay, it's very important in all these matters that you consult with your CPA. There are some businesses that they don't necessarily use CPA on a permanent basis, and at the end of the year, they go to a tax preparer. Be careful if you're going to do that. I strongly suggest that you utilize the resources that EDC SBDC provide to you, so we can give you some guidance. We have accountants such as Tony in our group. We have bookkeepers and other financial advisors that can update your financial dashboard. Be very aware of that. So, but do not move without consulting, because you may be going the incorrect way. For example, if it's a debt forgiveness, how is that going to be treated for tax purposes? So both for the landlord and for the tenant. So it's very important that you don't proceed without consulting with experts in this area.
Those are all excellent points, Gonzalo. And if we go to the next slide, please. Thank you. So as part of reviewing your financial picture, you should review your historical pre-COVID business profit and loss statement, cash flow, and tax returns. You may also consider developing, say, 6 to maybe 18-month monthly financial forecast going forward from this date. We have the advisors at the EDC have helped a number of business owners develop financial projection forecasts. That's an important process, and it's going to give you an idea as to when you may be in a place where you can start paying the full amount of your rent. If that and that would be a discussion point with your landlord, and you would share some of these financial documents with your landlord to let them know, give them a better idea of your financial picture, as it may be helpful. They may take this into consideration as they are negotiating some possible rent reduction or abatements. And to you, Gonzalo.
One very important point following what Tony just said, if you're going to end up on a negotiation, is to demonstrate the financial impact that COVID had on your business. And that's when you compare the historical numbers to the current numbers. It's very good to show that as to what it has been the financial damage that your business suffered during the COVID period, and is still probably suffering today. So having historical numbers and having current numbers together with the projections would be very important to illustrate your point.
All excellent points, Gonzalo. And finally, before meeting with your landlord, consult with your financial advisors. That is so important. Schedule sessions with EDC SBDC advisors to map out a plan and identify key lease negotiation strategies before entering into those sessions with your landlord. On a number of occasions, Erica, Gonzalo, Bill, and I had co-counseling sessions with business owners in an effort to assist them with talking through the lease points, financial projections, the importance of financial projections, the cash flow position of the company. And so, yes, and and consider scheduling a session in the next several weeks with an EDC SBDC advisor. To you, Bill.
Thank you, Tony. Thank you, Gonzalo. Thank you, Erica. The challenge at this point is to be responsive to current condition. The challenge is to assess your business position, your personal position, your emotional position, and think about that in terms of capacity. When we talk about negotiation, when we talk about facts or contracts, we've been at this now for a long time. And one of the things that's going to set the tone is how you have been able to respond, what your current capacity to respond to this crazed last year and a half, and has the COVID demonstrated other areas of organizational structure that needs attention that was a pre-existing condition? Do you have the capacity to take that on right now and to work through this? Or is this a time to pivot? Is this a time to think about next steps? Next slide, please. Normally in a disaster, there is a moment. In the COVID, this is what we think of as a long disaster. And so there are a whole series of repeating events that over time just wear us down collectively. And so when I think about helping or advising a client about negotiating or responding to, I want to talk about what is the relationship, both contractually and as relationship person to person, with your landlord, or if you're a landlord, with your tenants. Have you been talking to your tenants through this whole slow rolling disaster? If we are thinking about what am I going to do in 2 to 4 months, that's so far outside of the view of the next 3 days or the next 2 weeks. I think what's critical here is to understand that everybody has been tossed, including the banks. So if you are a landlord who has a tenancy to a bank, have you been talking to your bank? Has your bank been talking to you, and then you to your tenant? So just to think about what is your current capacity, emotionally, personally, and business-based, relative to the facts that come to your tenancy or your ownership of a property. And then from there, coming up with that plan, that offer. And to make sure that that plan or offer is based in the reality of both your ability to perform and also your ability to set bottom lines. Next slide, please. We jump past. Could you go back one slide? Thank you. So the critical piece here is the steps that we are looking at are based in this, everybody's in this all together. And it's not a comparative. I'm in a different place than you. It's being clear about, as Erica said, the location, because that is the body of law that you're going to be working with, the contract that is your lease, and then as you have maintained relationship, as you have talked to either as a landlord to the tenant, or as a tenant to the landlord, or as a landlord to the bank, or as a tenant to your bank, if that's also part of your relationship, to document, keep a journal, who, what, where, when, and let that inform the negotiation moving forward. If it's a hardline negotiation, how well or how much capacity do you have to negotiate into that hostile environment? Or if it's a warm relationship, is there an agreement? Make sure that that agreement is beyond a handshake and documented. So pass it on to Gonzalo.
Hi, Bill. Thank you. In the last part of this presentation that we're sharing with you, be aware that when you enter negotiations, and that applies to both parties, landlord and tenant, it's going to be a win-win situation. You cannot go in and negotiate and say, oh, I'm going to get everything is best for me and I don't care about the other party. That is not the solution to a problem. Okay, so in both cases, you have to look at each other and say, do we have a positive attitude? And if not, bring it up. Bring it up, because if you're reading one party incorrectly, that party can tell you, oh, no, I'm in good faith because X, Y, and Z. So, but that is very important so you don't waste time. Where we are right now, you cannot waste time. Before you start the negotiation, determine what is your goal. Don't go into the negotiation and says, I want my rent, all my past due rent to be forgiven. No, wait 1 second. Set a realistic goal, a monetary goal, a non-monetary goal. And also, as you enter the negotiation, understand what could be a realistic compromise. In most negotiations, you're not going to put something on the table and the other party is going to say, oh, sure, whatever you want. I don't think so. Okay. Following that, I recommend that you do not agree to a plan that have a low probability of achievement. And if you have the numbers, as we talk about in Tony's presentation, if you have the numbers that can demonstrate that, show the numbers again. So prior to the meeting, put all this in a piece of paper. Don't try to go in and, as they use the term, wing it. Okay, that's not the way to do a negotiation. And so you need to put all this in a piece of paper for you to remember to go in every detail, and also for you to respond what the other party will bring up. Prepare a realistic financial summary of your business for 2020 and year-to-date 2021. I mentioned before, okay, that comparison is going to demonstrate where your business is today, in which direction your business is going, and how you can achieve what you're proposing. The next slide, please. Listen to the other party. That's one problem that we humans sometimes have. Do not listen. Listen attentively to what the other party is saying and do not judge ahead of time. Take notes. So when you respond, okay, you can respond to those notes. It's not good when one party is making the presentation that you keep interrupting. Make sure that you let the other party present his or her point, and then respond with a reasonable balance between his or her needs and your previously stated resources. As I mentioned, I doubt that you're going to present your plan and the other party is going to say, sure, beautiful, no problem. I don't think that's the case. You got to be prepared to compromise. Okay, that's the importance of keeping the notes on the discussion so you know where you're compromising. Avoid threats, insults. That is going to get nowhere in the resolution of the problem. Both parties want to have a mutually beneficial resolution to the problem. It has to be amicable. If you start throwing things at each other, that is not going to go nowhere. It's going to go backwards. Allow yourself additional time to review the compromise. This is not the point. The first meeting is not the point to agree to a compromise. You need to review it. You need to go back, maybe consult with some people. If you need to have a legal advisor to consult, if CPA or some other business advisor, to make sure that you allow time for that. And you eventually, as Erica mentioned, you want to conclude with a documented binding agreement. Do not do these things via email. Do not do things verbally. You have to have a piece of paper signed by both parties indicating this is our binding agreement. Back to you, Tracy.
Thank you, Gonzalo. Thank you, everyone, so much. That is really excellent information. And it is a great overview of all the complexities here, things to consider, and what's reasonable. And I know these can be tense situations, so that really is a great overview to get us going. Today, we are also joined by Shanina Butler, the Executive Director of the Conflict Resolution Institute here in Camarillo. The Conflict Resolution Institute has provided mediation services since 1990 and has kindly joined us today to chat about the services that they can provide in Ventura, Santa Barbara, and Los Angeles counties to those dealing with tenancy-related issues. With that, Shanina, can you share some information with us?
Sure. Thank you so much, Tracy. Good afternoon. My name is Shanina Butler, and I am the Executive Director of the Conflict Resolution Institute, also known as CRI. And today I'm just going to briefly share some information about our Community Mediation Center, the services that we provide to the community, and why in the commercial eviction context, you may want to consider mediation as a dispute resolution option. Next slide, please. Next slide, please. There you go. Thank you. So who is CRI, or who is the Conflict Resolution Institute? So we are a community-based nonprofit organization, and we provide alternative dispute resolution services such as mediation. We also provide conflict resolution training and mediation skills training, and then conflict resolution education such as presentations to individuals and businesses in Ventura, Santa Barbara, and LA County, as Tracy said. Our offices are physically located in Ventura County near the Camarillo Airport. We were established in 1990 under the Dispute Resolution Program Act, also known as DRPA. So what that means is that we operate under the supervision of the California Department of Consumer Affairs. So DRPA allowed counties within the state of California to establish and fund community mediation centers such as ourselves. And if you look on the Department of Consumer Affairs website, you can see a list of local mediation providers broken down by county. But DRPA also sets forth the rules and regulations for those community mediation centers that they have to follow in providing mediation services. So the way that we train our mediators, the way that we assess fees or don't assess fees for certain participants, and also the way our services are evaluated. Next slide, please. So what ADR services do we provide specifically? Well, one is mediation. We provide in-house mediation and then also small claims court mediation. So in-house just means that anyone from the community, whether or not it's an individual or an organization, can contact us directly concerning a dispute that they're having, concerning a commercial eviction issue. In small claims court, we are there in Ventura and Simi Valley when the courts are fully open, and we mediate those small claim cases the day of. With respect to the pandemic, we have been providing mediations that are online. We also offer arbitration services, facilitation services referred to larger group conversations that happen. And in 2020, in response to the community need, we facilitated several community dialogues concerning issues of race and equity. And then finally, conciliation services. We help debtors negotiate with their creditors in terms of those credit card debts. And then you may ask, what types of disputes do we mediate? We mediate really all types of disputes, but this is just a small breakdown of some of the disputes specifically. So landlord-tenant issues, commercial and residential, contract, family, HOA, real estate, civil harassment. Next slide, please. So how much do our services cost? So we are regulated by the Dispute Resolution Program Act. And so our mediation services are offered on a sliding scale based on income for individuals and based on gross revenue for organizations and businesses. And for some parties who are considered indigent, our services are provided at no cost at all. But really what's important is that our underlying philosophy is that we are committed to serving all community members regardless of ability to pay. So if you're considering mediation, if you have questions about mediation, please do not hesitate to contact us because of a concern about the cost. We want to work with you and we are here to be of service. Next slide, please. So in the commercial eviction context in particular, why would you want to consider mediation? 3 reasons. Your attempts to negotiate directly have not been successful. So as the EDC advisors explained earlier, you are prepared for negotiation, you prepared your finances, you prepared your strategy, you mentally prepared, but your attempts to negotiate directly have not been successful. There are 3 elements that are necessary for effective communication. There's speaking, there's listening, and there's this 3rd element of being heard, which is often missing from most communications. And that can be the source, and that often is the source of much conflict and much dispute. In mediation, the mediators are third-party trained neutrals. They have been trained to facilitate communication and to allow and to make sure that the parties are feeling like they've been heard. And when an individual feels like they've been heard, the doors really open. The conversation changes, the tone changes, the emotions change, and emotions can be de-escalated, but there also is an opportunity to then negotiate, to then work towards resolution and possibly also agreement. The second reason you may want to consider mediation would be mediation requires less time and less money than litigation generally. As you may be aware, courts are backlogged, right? Just because eviction moratoriums, eviction protections lapse, that doesn't mean that there is going to be a swift resolution to your dispute. In Ventura County, parties can pay anywhere from $200 to $400 and more to file or answer a complaint. And that doesn't even account for the time that you're spending drafting the complaint, answering the complaint, serving the complaint, showing up in court for the hearing, if you obtain a judgment, collecting on that judgment. Mediation sessions can be more than 1 session, but traditionally they're 1 session ranging anywhere from 2 hours or more. And also, if you're working with a community mediation center, the cost to you will generally be less than what you would spend in litigation. And then finally, mediation is confidential and the parties determine the outcome, whether or not that's a payment plan or a vacancy date. Litigation is uncertain. There are no slam dunks when it comes to litigation. What we're seeing is that corporate tenants in the commercial eviction context, they can declare bankruptcy, they can abandon the corporation, they can raise unusual defenses such as force majeure, and you don't know how a judge is going to rule in terms of that. Mediation, because it's confidential, because those confidentiality provisions are enshrined in the evidence code, that allows parties to have these frank discussions, these open and honest discussions about what it is that they need, working towards a payment plan and possibly also a guaranteed move-out date. So more certainty in mediation versus litigation. And then also, if there is agreement, as the EDC advisors talked about earlier, being important to put that agreement in writing. The mediator can assist with that, helping the parties to draft a binding written agreement. Mediation also generally does not preclude you exercising your legal rights under the law. As was stated earlier, you want to check the terms of your lease or your written provision concerning dispute resolution provisions. You also may want to consult with a legal advisor, but in general, mediation does not preclude you from exercising your rights under the law. You can still attempt mediation while pursuing those legal rights. So in closing, next slide, please. If you have any questions about mediation in general, the mediation process in particular, please contact us. If you think that mediation makes sense in terms of a dispute resolution option for you, please contact us. The best way to contact us is via email or by phone. Our email is info@conflictresolutionvc.org. So we look forward to being of service, and thank you for your time today. Thank you, Tracy.
Thank you so much, Shanina. That is fantastic information. So I want to thank you not only for your time, but also for joining us. We're really excited to share information about the Conflict Resolution Institute. So we do appreciate you joining us today. And I know that you're also going to hang out with us for a little while longer. So we are ready to move into our question and answer portion of today's webinar. So if any of our attendees do have questions for our presenters, our SBDC advisors, or Shanina, you can put it in the Q&A section at the bottom of your screen. I don't see any questions currently, but that gives me an opportunity. I actually have a couple of questions for our advisors that I would love to ask. Let's see. So one of the things I'm hoping our advisors can discuss is what have some successful businesses done to survive the pandemic?
I have one right now that they were able to accept the landlord with two things. Number one is a discount on the back due rent. And number two is the ability to generate a note for the difference. And that note is going to be dependent on the cash flow generated by the business over the next few years. Now, that means that the business has to share financial information with the landlord. There is still a point to be resolved. When you have a lease, remember you have the rent and you have the common area maintenance known as CAM expenses that you have to pay separate. And so that is a separate negotiation because that's an expense, direct expense that the landlord has incurred and continued to incur. So that one has not yet been resolved, how much of that will be forgiven or how much could that be put on another note. My recommendation is that they have two notes, one for the rent, one for the CAM charges. So that's, so far they have agreed to the rent. That's a positive thing. And so right now they're still negotiating on the CAM.
That's great. Those sound like some great options. Erica, I see you're unmuted. Did you have one thing to mention?
Yes, we had a landlord and tenant situation where how they resolved the rent was to have a payment plan for the unpaid rent over a certain number of years. They also extended the lease term to an additional year or two for the landlord to recoup additional revenue with escalating rent on a normal rate. But then also for a certain period, the landlord and tenant, the rent going forward, looked at the revenue compared to the previous revenue and the number of clients and customers that had come back. And they did a stair step. So the tenant would constantly provide financials. And as the revenue grew, the rent would go back up to the normal level if it did, right? And so that was a good concession. It took into account the tenant's increasing revenue without having a flat lower fee that the landlord lost out on. And it helped the clients to communicate because they're constantly speaking with each other. Of course, those documents should be held confidential by the landlord, and any tenant who is agreeing to this type of thing, remember that you need to be honest and truthful about your ability to perform your agreement. If you go into your agreement knowing that you can't perform it and you're just trying to get the landlord off your back, that could be fraud, contractual fraud, which could expose you to additional liability. So I think Shanina talked about communication and talking with each other. They got on the horn early and often and worked it out because the landlords, it's not just a tenant distress. The landlords aren't getting revenue from this rent, which is hurting them as well. So they're both trying to help each other to survive. And I think that was a good compromise in that case.
That is really excellent. That does continue to be a very specific point. It's a tense situation, but absolutely you can't agree to things that you can't actually provide. You know, that's just, we do feel for all the situations out there, but it's unfortunately is not the best opportunity in the end. We do have a couple of questions here. So let's start with a question from Sean. Their lease expired in November of 2020, and they are asking, what is a reasonable amount of rent forgiveness that they might ask for? It seems like they've been paying about 50% of their rent since last summer.
I think the word there is reasonable. And depends who look at reasonable. Remember, the landlord normally will have a lender. And I think Erica mentioned it, that the lender may not allow at least rent forgiveness or modification of rents or anything like that. So it needs discussion. Is not reasonable. It has many definitions, and in this case, is what can be acceptable and manageable by the landlord. So talk. You have to discuss it. And when you give the landlord some information, that landlord then can go to a lender and say, hey, I know you told me this, but here's my situation. Typically, the lender does not want to lose money. So they're not. But the lender also is willing to compromise because their main objective is, how do I collect my loan back? The lender has another set of supervisors on the background called regulators. And they have to put these actions in a file that when the regulators come in, can say, okay, that makes sense, that decision you took to allow this borrower to do this and this and this. So it's not something that stops in the lender. Give the lender some ammunition so they can make a decision. So be careful with that, okay? So that's reasonable, has a lot of understanding in there, okay?
And also, Tracy and the client who asked the question, I wouldn't just assume that the landlord is going to forgive anything, right? That's a negotiation, whether they forgive back rent. I mean, if you feel like you need to talk with a lawyer, it is a contract law situation. So if there are any contract law defenses to non-performance, that's something that you might want to discuss with a lawyer. If you feel you don't have to pay it or you don't want to pay it, I would definitely get a legal opinion on that. But I wouldn't come into it assuming that the landlord must or should forgive any back rent. That's part of the negotiation. The landlord may say, I've allowed you to pay reduced rent. And this is one thing I think that tenants need to be clear on, because we had an issue with a client on this. A client was paying reduced rent, and neither party had clarified whether the unpaid portion had to be repaid at some point or not. And the tenant thought, well, the reduced rent just means I can pay 50% and you're waiving that other 50%. And the landlord said, no, I'm just allowing you to pay reduced rent to survive, right? And then at some point we'll talk about the unpaid. So if you're going to enter a negotiation where somebody is allowing you as a commercial tenant to pay reduced rent, you need to deal with, is that a waiver of the other half, or do you have to pay that back at some point? Again, I wouldn't assume the landlord is waiving it. It's a negotiation, and you as a commercial tenant need to come up with some good reasons why you should get to have that waived. Either that debt will send your business into a tailspin, which may cause you not to be able to pay anything at all, or it may cause you to go insolvent, right? You should have some arguments as to why that amount should be waived, which leads to a win-win for both.
To follow up with that, when I hear the word assume, when you're talking about this kind of negotiation, it's based on contract and contract language. There are very few assumptions, and the negotiation we're talking about is to modify those agreements which are contractual. So I assume is always a bad position.
Absolutely. Before I jump in, Anthony, I see that you're unmuted. Did you have something you wanted to add here?
Other than, and all excellent points from the other advisors. one of the things that at this point in time, I would think that there's been discussion all along, and so it's whether the landlord has expressed some intent to forgive a certain portion of the past due rent. I would think that that would have already been discussed.
And also to remember to be aware of your eviction moratorium protections. In some cities or some counties, you may have 1 year to pay back the unpaid rent, right? If you're getting pressured to pay it back within 3 months, which is going to send you in a tailspin, you may have greater rights under the eviction moratorium than you do in your negotiation. And so we've had some tenants discuss with the landlord that paying this whole amount in rent is going to cause them not to have enough capital and operational expenses to run the business to survive. So if all of their money is being focused on rent, they may not be able to generate revenue because they don't have money to do marketing or to buy inventory. So it's a discussion, right, of why you don't want to pay it and making sure you know your rights.
Excellent points all around. And I think it was said perfectly that unfortunately, nothing in this situation is a given. And Gonzalo said it perfectly that in the terms of Sean's question of what is or isn't reasonable, it's all about talking. All of this comes down to making sure that you know where you're at and then sharing that with your landlord or vice versa. And that's one of the things that Shanina's organization can help you with if you are having a harder time getting in touch with them. We do have another question that looks like it is directed towards the Conflict Resolution Institute. Pam says, we have some business equipment leases and they will not respond to us about trying to renegotiate the payments. Can the Conflict Resolution Institute help our business to get the leaseholders to correspond with us?
I will say that, so one of the principles of mediation, in addition to it being confidential, is that it's also a voluntary process, right? So as a part of what we do when a party, an individual or business contacts us, we take in that information, there's an intake process, and we also reach out to the other party in the conflict or the dispute. But ultimately, it will be voluntary in terms of whether or not they respond. What I can also say, though, is that sometimes the right thing at the wrong time is the wrong thing, meaning that sometimes it's an issue of timing, right? And sometimes businesses may not be willing initially, right, to correspond, but at a later point, they may be. They may be willing to, correspond if, a third party reaches out to them as opposed to you, and assuming that you have some type of history with that business as well.
JJ, let me add something to that. A leasing company, a lessor, is a lender. It's another form of lending. You might be speaking to a person that is in the front side of the business development type person or a credit person. You need to speak to what is known as a loan workout department or lease workout department, which is another word for a collection department. Talk to those individuals who are the ones who can make those kinds of decisions. You may be talking to the wrong person when you want to negotiate. The people up front do not have authority to negotiate. The people on the back, they are the ones who have authority, so you need to get to them.
That is absolutely true. As Shanina said, mediation is a voluntary process, but as Gonzalo said, it might not have been the right person. So there could be some more work to be done there. So I'm really glad that you did mention that, because there are some cases where whoever you were originally in contact with is just not the person who would be able to help with this kind of situation. So thank you for bringing that up.
I want to add one more point, and that has something to do that Erica mentioned in her presentation.
Please.
That I find it very often these days. I want to sell my business. Why can I sell it? You have to, if you have a loan with the government, EIDL is a loan. PPP is a forgiveness loan. So I'm talking about EIDL loan. remember that those people took a lien on the assets of your business. And it says very clearly in the documents that you sign that you cannot sell or transfer or buy any kind of business, okay, without their consent. Be sure you get their approval. I know 2 people that have received approval to sell, okay, but they went to the right procedure, the right protocol to get it done. So do not sell, because that sale could be canceled or voided, okay, by them, because they own the assets of your business. They have a lien on it. They don't own it, they have a lien on it. So be careful with that. It's happening more and more. The companies that want to sell or buy need to get approval from the SBA EIDL.
It's a really great point. That is a technical point. You know, it's one of those situations that not everyone's in it, but it is one of those minor details that is important to keep in mind when you do have loans like EIDL. Let's see, I'd like to ask all of our advisors and presenters, what are some considerations for commercial tenants and landlords that are perhaps at a crossroads in their business? They're not really sure what to do moving forward. Anything to add here?
I missed at the middle of your question. What are some what?
What are some
Repeat it, please.
considerations? What are considerations for commercial tenants and landlords that are at a crossroads in their business? They're not sure what to do moving forward. Any recommendations?
Well,
So in some cases,
go ahead, Tony.
In some cases, bankruptcy may be an option or of the path to consider. And as part of that that process, the business owner would need to consult with and retain an attorney, ideally a bankruptcy attorney, to give them some advice in that matter.
Thank you, Anthony.
My adding to what Tony said, talk before you get to that point. Do not close the doors. Both parties, landlord and business owners, they have vested interest in a amicable and mutually beneficial resolution. Okay, so everybody understand what happened in 2020 and it's still happening today. So I hate for somebody to have to lose their sacrifices and their capital because they have not been enough conversation. I think the conflict resolution could be a beautiful avenue to pursue, to follow before you take an extreme decision, okay? So be sure you use them all.
Yes, absolutely. I'm thrilled Shanina was here today to be able to share information about this resource in our region. If our attendees do have any questions, please feel free to put them in the Q&A. We do have a little bit more time here, but as we give it that a minute, I want to ask all of our advisors. I know that Bill Bartels had to hop off a little bit early, but we still have with us Erica, Anthony, and Gonzalo. If there's one thing that you really want our listeners, our audience here to take away from this webinar, what's that important thing that a tenant or landlord should be preparing for right now? Erica, can you speak to this?
Sure. I would say find your lease, please. You know, sometimes we have clients who signed a lease 5 years, 10 years ago. They have no idea where that lease is. The lease may have attachments, amendments, it may have personal guarantees. And many of our clients have signed that document. They didn't read it. They didn't understand it. Like a lot of us do with loans, they just look at the monthly payment, right? And they really don't know all the legal considerations in their the lease. Again, the lease is a contract. The failure to pay rent is breach of contract. Remedies are unlawful detainer, but there are other remedies. So go and find your lease today. Put every single piece together. If it was amended, find every single piece of the amendment. If there's attachments, if there's other personal guarantees, other related contracts, get all that together, because you may need to talk with somebody or talk with one of us And to answer your question about a business owner in Crossroads, reach out to the SBDC. I can take a look at the lease. I can't give you legal advice, but I can point out some things. Tony and Gonzalo can talk about the financial situation. Bill can help you look at the big picture. Some commercial landlords have other tenants who want that space. This may be a great opportunity for you to move to a smaller space or a different space in the complex that's cheaper rent. So that really could be, we've had some clients who the landlord offered them a smaller space. It was great because the rent was less. They didn't need that space. And then the landlord could move in a tenant who could pay the full rent or the market rate. There's always options there. So find your lease, know your commercial eviction moratorium that applies both the landlord and the tenant, and then see if there's some options and give the SBDC a call before you leave.
Eviction and rent problems are not going to go away. Do not hide. Face it. You know, be upfront with it. Take the steps necessary. Some people think, oh, if I don't do anything, it may go away. It's not going to go away. Okay, be real. Be real and face what the situation is today. Okay.
Erica, what happens if the lease expired, let's say March of last year?
Well, I mean, there's some legal issues there. If the landlord is collecting rent and the tenant is paying the rent, it may be looked at as a month-to-month lease. That is the problem, again, where if the landlord decides not to terminate because the tenant has a COVID-19 hardship, but just because the lease term expired, that tenant now has to move all of their things out. And the courts may say this isn't something under the eviction moratorium protection because the tenant may be able to pay the rent, right? It's not always that the tenant can't pay the rent. So you have some risk there that your lease is expired and it's just an unlawful detainer because you're trespassing, right? Not because you have a COVID-19 hardship. So you may need a lawyer to give you a legal analysis. Are you still in a lease term? Some eviction moratoriums, I think maybe Ventura or Santa Barbara, I have to double check. At least one of them say if your lease is ended, the landlord has to provide an extension on that till the protection is over. It might be Santa Barbara. Got to double check. So you need to look at your eviction moratoriums. I want to remind commercial tenants one more thing. If you allow this to go into unlawful detainer, that's going to go on your credit, right? That's going to go on your business credit if you have a commercial eviction. Think about how hard that will be renting another space if you've got that on your credit, or if you have to report to the landlord, to your new landlord or prospective landlord that you've been evicted. That's not going to be an attractive application. So if you can resolve it by a mutual termination, a mutual move out, or a closing or sale of the business, or move it before you move on to do something else, if you can avoid having that unlawful detainer or a commercial eviction on your credit history and having to put that on the application, that's another reason to negotiate.
Thank you, Erica. Appreciate that. It's great points all around. And then I did want to ask Anthony, do you have an additional point that you want to add for that last takeaway, things for people to keep in mind and focus on moving forward?
Yes, I want to emphasize the importance of reviewing and summarizing your current financial position before your discussions with the landlord. That is important. We've seen cases and situations where the business owner, their operations have declined substantially because of not being able to open for 8 or 9 months, and they're behind in their rent. Some have made the decision to close their businesses, and but yeah, the importance of reviewing your financial situation, your tax returns, your outstanding debt with your suppliers, outstanding receivables, and your ability to go forward with the business.
Thank you. I know that that is a lot of information. We've helped provide a lot of things to be considering all at once, a lot of paperwork you should definitely be keeping track of, but our SBDC advisors can help chat with you, kind of walk through the situation a little bit. We do have a question from Elizabeth who asks, who can I talk to have help for rent assistance? And I will quickly mention that that will depend on likely where you're located and what the protections are in your area. And I'd like to echo what Erica mentioned, that our SBDC advisors can help you look at your overall financial situation and help you address some questions like that. But advisors, do you have anything to mention on this one? Where might be some places to churn?
I think it also depends, are you talking residential or commercial? There's not a great commercial source for commercial rent help, but there are grants, right, and other loans that you may be able to take advantage of. So I think it depends. And are you talking commercial or residential? And then, reach out to us and we can try to help you either way, loans or grants. And then there are rental assistance. There's a statewide for residential. There is rental assistance on a statewide level. And there also are some county programs. Some have ended, some may still be in effect. We can try to help you research those if you need.
Fantastic, thank you. Yes, Elizabeth, I'll recommend that you do reach out to our center. So this is actually a great time if the Visionality team could bring back up those slides.
Yep, give me 1 second, I had closed it, sorry, 1 second.
No problem, we'll just share some information on how then you get in contact with us. And we'll put it up on the screen for easy viewing, and I know we'll add it to the chat as well. While we get those up, I'll take the moment to truly thank all of our presenters and Shanina, not only just for your time, but you also continue to show and have an excellent commitment to our small businesses, our community as a whole. So I appreciate your time and your experience as always. In addition to helping you with tenant and landlord needs, the EDC consultants are ready to answer your questions and help you navigate through today's complex business environment. You can access advising in finance, marketing, legal compliance, international trade, and so much more. You can get started by calling our business assistance line at 805-409-9159. Again, that's 805-409-9159. Calling would also be your first step to learning more about our local loan program. As I mentioned, we're going to send a follow-up email with a recording of today's presentation and all of these PowerPoint slides in case you're interested in reviewing any of the information. But that is all that we have today. Unless our advisors have any last-minute items to mention, I just want to thank all of our attendees for being with us. All right, have a wonderful rest of your afternoon, everyone. Thanks for joining us.